Good morning, everyone. My name is Peter Gore, and I am the Executive Vice President at the Maine State Chamber of Commerce. And we want to welcome you to our 2021 Human Resources Forum, which is an update on HR issues which are currently in front of the legislature, and we think you ought to know about.
Reduce the scope here, though.
We're pleased to have a nice crowd here this morning. And Angie, there we go. Here's our how the logistics of today are going to go. Meeting is being recorded and it will be available on our website, probably not today, but maybe tomorrow. People are on mute, and so that it's a listen only mode. If you have questions, what we're going to do is ask you to type those questions into the chat box, which I'm sure all of you have done enough Zoom to know that it's on the bottom of your screen. And rather than loop back and do questions at the end, Anne-Marie and I have agreed to ask questions or answer questions as we go along based on the different issues we're going to take up. And again, if there are meeting materials, there'll also be an attachment on our website. So our sponsors this morning, our presenting sponsor is Rudman & Winchell, and our break sponsor is Husson University. We want to thank them both for their support. We'll have a message from Husson.
Good morning. My name is Marie Hansen, and I am the Dean for the College of Business and New England School of Communications at Husson University. On behalf of Husson University, we are pleased to join you this morning to support the Maine State Chamber in this Human Resources Issues Update webinar. This forum today aligns with what we find important, supporting the employees as well as the business community and the Maine economy. We are looking to establish partnerships with your businesses to provide a variety of benefits, including internships, discounts on courses, and degrees for your employees. This is an exciting time for the largest College of Business in the state of Maine. We will be opening our new College of Business building in Bangor this fall, 2021. Where students and the community will be welcome to learn and interact.
All righty. So, again, good morning. Our presenter this morning is Anne-Marie Story. She is a partner at the firm of Rudman & Winchell, where she practices employment law, including advising employers on litigation, administrative actions, training, workers' comp. And she's a frequent speaker with us and with other HR-related professionals and groups. She is a graduate she graduated cum laude from Vermont Law School, and she is a past president of the Maine State Bar Association and is a member of the Maine Board of Overseers of the Bar Professional Ethics Commission. She was born in New York City, grew up primarily in Virginia, graduated from Middlebury College, served in the Peace Corps, and she now lives in Winterport with her family. So please welcome Anne-Marie this morning.
Morning.
We've agreed to tag team off a little bit, whereas I'll serve as sort of the moderator, and we'll rely on Anne-Marie's expertise on a variety of these different bills, and we'll talk a little bit about where the legislature is from both individual bill by bill process, but also a little bit larger on the process this session and how that process is working and how you can get involved with it, we hope, especially after you hear some of what we're talking about. Did I miss anything, Anne-Marie?
Oh, sounds good so far.
Okay. So the Labor and Housing Committee has assigned all of the bills we're going to talk about this morning. It's the primary committee of jurisdiction when it comes to labor issues. And there are quite a few, and there are quite a few significant bills out there, some more significant than others, all of which will have an impact on you if you're an HR professional or you have HR responsibilities in your workplace. I think we should probably get right into it since we're limited to 60 minutes and we can touch on the process. So Anne-Marie, you and I have talked a little bit about the first bill, LD 61, an act to include grandparents under Maine's family medical leave laws. Just so folks know, this bill has already had a public hearing and a work session as it's been voted on by the Labor Committee. If you an update on where it is after Anne Marie talks a little bit about what it's designed to do.
Thanks, Peter. So this bill, as you said, amends the Maine Family Medical Leave Act, not the federal. So employers will have to be sure that everybody who's subject to the federal would also be subject to the Maine. And this will now provide a reason for leave that is not covered under federal. So potentially additional leave time is what this would create. But what it does is it amends a very particular section of the Maine Family Medical Leave Law, and it will now include grandchildren under the section for a reason to take leave for a serious medical condition. So that's important because it doesn't include grandparents for purposes of all of the reasons that somebody might be eligible for family medical leave. So in other words, if you have an employee who is a grandparent, they would be eligible to take family medical leave for a grandchild or a domestic partner's grandchild, but only for a serious health condition. So again, this is limited to serious health condition of the grandchild, and it doesn't work in the opposite way. So it's not covering an employee who is a grandchild and wants to take leave for a grandparent. It's only an employee who is a grandparent taking leave for a grandchild. So it's important to understand that limitation. And again, the only reason proposed by this bill for the leave would be a serious health condition. So Peter, it's a little more limited than just a broad amendment of the Family Medical Leave Act, but of course important again, because as we all have maybe experienced or at least know, an employee is entitled to leave under the federal law, and if they also qualify for leave under state, this now potentially gives them a reason that would not be covered under federal. And so potentially now an employee covered by this amendment would be able to take the Maine family leave time, 10 weeks in a 2-year period, but also still be eligible to take federal family medical leave for a qualifying reason, because it would not include this reason as well, if that makes sense.
So does that mean, Anne Marie, they could stack the leave, or they would just have access to the state statute because of the inclusion of grandchildren?
That's right. So somebody could take the 10 weeks in a 2-year period specific to the reason for a grandchild with a serious health condition, but because that reason is not also covered under federal law, an employee could then take a separate amount of the 12 weeks of leave in a 1-year period under federal for a different qualifying reason.
So Anne Marie, we already have a question, and it's the question that I brought up. First of all, the chamber did oppose this bill as being an expansion that will just add to the already administratively burdensome FMLA leave and the issues that we hear back from. But the question is, does the grandparent have to be the primary caregiver? And this is something that I addressed in my testimony, but I'll let Anne Marie speak to it.
Well, all I can say is that it doesn't say. It
Right.
simply adds grandparent or domestic partner or grandchild or domestic partner grandchild, and it doesn't put any parameters on what that means in terms of parental responsibility or standing in the place of a parent.
The discussion in the Labor Committee and what the legislative record would indicate is that this issue did come up, and would there be a requirement for primary custody? Would the children have to be, if the children had been removed from the custody of the parents, if the parents were deceased, or if parents were also taking FMLA leave and then the grandparents would now be eligible as well? We asked the committee to clarify this, and they did not do it. So I think the argument here, or the end result is, it was not the intent of the committee to require the grandchildren to be in the custody of the grandparents.
And one of the when it had an emergency preamble, one of the paragraphs in that preamble mentioned that this was important, especially in light of the increasing number of COVID cases. And so it may be that the presumption is, if a parent is ill with COVID or a related illness, they're looking to allow a grandparent to step in and take care of the child. Or if a parent has to work and the child is ill, they're looking to give more coverage to help parents out. So I don't, that's only a presumption based on that preamble language.
And COVID was brought up, but so were issues around childcare and the lack of childcare that some families were experiencing, and how grandparents could play a role in that. That's different from a serious health condition, obviously, unless the lack of childcare that was somehow related to COVID-19 and the parents in the home. It was not clear, but they didn't make custody a requirement under the law. So as Anne Marie just spoke to, this bill did have an emergency preamble on it. And what that means is it needed to be enacted in the legislature by 2/3 in order for it to become law as an emergency. But if it had been, it would then go to the governor. And if the governor approved it and the Department of Labor testified in support of the bill, then it would become law upon the signature of the governor. Non-emergency bills become law 90 days after the end of the legislative session, when the legislature adjourns. So usually it's sometime in October when the bills become law. In this case, the bill failed enactment. They did not get the 2/3 necessary. So it remains tied up in the legislature. It's not clear when they're going to meet on this again. The solution for the supporters of this bill will to remove the emergency preamble, which they can do, and just enact it as a regular bill. That at least gives employers time to adjust to this new expansion of FMLA until the fall. Anne Marie, we have a question. It's a request. Can you reiterate the federal FMLA, how that plays with the Maine allotment for FMLA?
Sure. So what I was describing is that most employers who are covered by federal FMLA are also covered by Maine FMLA, because of course the number requirement to be covered by Maine is lower than federal. So if you are an employer with 50 or more employees, then you're covered by both federal and state. If this amendment goes through, what that means is there's now a provision in the state law that is not covered by the federal law as well. So that means that somebody could potentially take leave under this amendment and utilize state FMLA and not use up their federal, because you can't run them concurrently unless it's a category that's covered under both laws. So, and we've seen this happen before. It happened back when the laws were first amended to add domestic partners, and it's happened in a few other situations. And so as a practical matter, what it means is an employee could request leave to care for a grandchild and use their FMLA entitlement of 10 weeks in a 2-year period. And at the same time, or when they finish that leave, if they, let's say they break an arm or something, and that is a condition covered by federal law as well, then they would still potentially be entitled to their 12-week allotment under federal FMLA.
And we got a thank you. Perfect.
Yeah, that's great. I can't ask for more than that.
That's right. Okay, we're going to jump to the next bill. This is a bill that has also had a public hearing, but not a work session yet in front of the Labor Committee. We did oppose it. It's LD 447, an act to require equivalent paid parental leave for all parents employed by companies offering paid parental leave. That's a mouthful. And the bill is one that Anne Marie and I have both discussed. It's hard to know exactly what it's trying to do, but I'll let Anne Marie give her analysis of it.
Yeah, I have to admit to being confused by the way this is being presented, because without getting into too much technicality, what it's doing is attempting to amend, the Maine FMLA to add a section for parental leave, except that the way that parental leave is defined by the proposed amendment, it's already included in the Maine FMLA, because the Maine FMLA already includes coverage for birth of a child or the employee's domestic partner's child or adoption of a child 16 or less with the employee or the domestic partner. Those are already categories covered by Maine FMLA. And the only other thing it does is that it then adds a section to the judicial enforcement provision of the Maine FMLA that says if an employer provides paid parental leave, the employer has to offer an equal amount of paid parental leave for the birth of a child as defined in the FMLA. And it goes on to say that if you provide paid parental leave, you can't offer different amounts of paid parental leave based on the gender of the employee or the employee's domestic partner. So I think the concept is very simple, that if an employer is going to offer paid parental leave, it has to do so on a non-discriminatory basis in terms of the gender of the employee and the employee's domestic partner, which of course it would already be required to do under general non-discriminatory provisions of the EEOC and the ADA, not the ADA, but the EEOC, Title VII. So that's the first thing that confuses me a little bit about that. But even if it were just simply clarifying that, it doesn't appear to fit within the Maine FMLA because it's not adding anything to the Maine FMLA that doesn't already exist there. The only thing that's different about Maine FMLA is that the leave that an employer has to provide for this parental leave can be unpaid. And so this provision, of course, is talking about paid parental leave. So I'm not sure if what they're trying to say is if you have a separate policy outside of the FMLA that provides for some sort of paid parental maternity or paternity leave, then if you're offering it, if it's leave covered under the FMLA, then you also have to give that paid leave to the employee. I don't know if that's the intent or not. That's not what it says. So I'm hoping that we can get some clarification when they go through the work session, number one, about whether this really does belong in the FMLA, and just to clarify what exactly it is they're trying to accomplish.
There is a question, Anne Marie. The person says, I'm confused. We pay short-term disability to employees that give birth naturally or have C-sections medically, not paid to bond with a child. Does this make a difference?
Well, I think that's different in the sense that short-term disability would be for a medical reason. And so the application of that kind of leave between a female giving birth to the child and a male or a domestic partner who did not give birth is a reasonable distinction, as long as short-term disability makes a determination that there actually is a short-term disability related to that condition. So it's the same thing as the application of the FMLA. FMLA can apply to each parent differently. So while each parent or domestic partner could be entitled to parental leave, which is the bonding time, and they would be entitled to that on an equal basis, the female who's giving birth to the child may also develop a medical condition, which would be a different kind of FMLA leave. And so I think that distinction is important and okay to make. But to the extent that you're just offering a broadly based, here's some time off to bond with the birth of a baby, then it has to be done on a non-discriminatory basis, regardless of the gender of the parent.
I would also add that if it's actual short-term disability policy, then I don't think this piece of legislation would impact that, because they're dealing with just the family medical leave statute directly. So I think there is a difference.
Yeah.
So folks know there was a mixture of testimony on this bill, not a lot of support. Folks that were neither for nor against, who were confused as to what the bill does. And the fact that it sought gender equity is something that I pointed and others pointed out is already covered under the Maine Human Rights Act in particular. So the purpose of the bill is really unclear. And I honestly don't know the sponsor understands what they were trying to prove. So we'll just see where it goes from a work session standpoint.
I mean, my hope is that someone will be able to articulate, here's the problem that we think needs to be fixed. And then we can figure out, does it actually need a solution, or is it already covered under the FMLA as it exists?
Yeah, and I think this was very much a solution in search of a problem.
Yeah.
Except that, and this is a theme that we'll talk about, it's an ongoing attempt by the legislature to regulate voluntary benefits to employees that employers provide. And the risk in doing so is that employers who are voluntarily providing these benefits stop providing them. And I told the legislature that that was one of the, that could be one of the very outputs of legislation like this. A quick question, Anne Marie, can you confirm the business size that FMLA applies to? I know, but I'll let you do it.
Yeah, so Maine FMLA is 15 or more employees, and federal is 50 or more, although there are some, some little parameters in there as well, but those are the general qualifying numbers. So that an employer who has 50 or more would be subject to both state and federal, but you can have plenty of employers who are subject to state but not have enough to be subject to federal.
Okay, we're going to jump to the next bill, and this is one of the more important bills of the session. SLD 553, an act to end at-will employment in Maine. This bill is actually scheduled for a public hearing next Wednesday before that Labor and Housing Committee. And I'm going to make an appeal to any of the employers that are on this webinar this morning to consider either submitting testimony in writing or signing up to deliver testimony in opposition to this bill. This is a very significant piece of labor-related legislation. It was last debated 20 years ago. That was the last time I had to deal with this issue in the State House. It is a significant, it would be a landmark change to how employment law works in this state, and would make Maine one of only 2 states in the country that operate under a pure for-cause termination or discipline procedure. So, Anne Marie, I'll let you go through the intricacies of the bill.
Yeah, this is very significant. And so what it would do is change the at-will, would essentially remove at-will employment. And we can talk about whether that, how that actually exists now anyway, because of course there are some limitations on it, but it would remove it completely and indicate that an employer may not terminate without cause, which is defined in the proposal, and that you can only terminate for cause if you have followed a progressive disciplinary policy. And the parameters of what that disciplinary policy have to be is spelled out in the amendment. Among other things, it would require a 3-step disciplinary process prior to termination, starting with a verbal warning, then going to a written warning, and then a final written warning. And then there are parameters on what each warning has to do. It has to provide certain information, has to be accompanied by written documentation of the specific basis for the warning. It has to include language in the final written warning that any further instances will result in termination. The employee has to be required to sign a copy of the final written warning. And then once you get to the point of termination, you have to provide it to the employee, inform them they're being terminated with the explanation of the cause or the causes with written documentation and the effective date of the termination, and then you must mail it also to the employee on that same day. So what it also says is that if you don't have a progressive disciplinary policy currently in place, the Department of Labor is going to develop one that you could then adopt. And in fact, you would have to adopt it if you didn't have your own progressive disciplinary policy that complied with the requirements of this section. The only exception to this process, and as it currently written in this bill, is it says if an employee has violated any state law then you're not required to follow the progressive disciplinary policy and may proceed to immediate termination with notice. However, among all of the other problems that we have identified already with this language, there is no description or parameters on what that means in terms of a violation of state law. So does that mean that as an employer, it's my impression that what you did violates state law? So for instance, let's say you have an employee that you suspect of theft. Well, that would be a violation of state law, but do you have to actually prosecute the person and get a conviction in order to qualify under this section and allow you to terminate without going through the progressive disciplinary policy? Because that could take a period of weeks, months, years, who knows how long. And are you supposed to keep the person employed during all that period of time? So we don't know the answer to that. And what about lesser violations that might not be like a harassment situation? Suppose you have an employee who is accused of sexual harassment, and whether or not that's a violation of state law is not clear. Does that mean that you can't immediately take action against that person and remove them from the workplace? It appears from this language as though that's the case, because you got to go through a progressive disciplinary policy. What happens if, well, and it also doesn't define what termination means. So, Peter and I talked the other day about what does that mean in terms of a layoff? Are you even permitted to do layoffs, or you have to follow a progressive disciplinary policy or a progressive layoff policy before you can do that? It also doesn't make any parameters for a probationary period. So while probationary periods are sort of a misnomer in the realm of private employment anyway, it doesn't make any provision for that at all. So once you, according to the language now, the minute you hire this person, you are now subject to the 4-cause standard, and you have to go through the 3-step progressive disciplinary policy. It's a massive, I mean, it couldn't be a more dramatic change to the current way that we operate.
If that doesn't scare people, I don't know what should. It's in particular the issue of, whether the violated state law really opens the door for employers to have some very difficult situations, because if in fact, it's a violation of state law, it may be in the employer's eyes, but perhaps, the litigator that the aggrieved employee would hire to represent them in an unfair discharge claim would see it otherwise and say, well, it wasn't proven. It opens the door for all kinds of litigation. It opens the door for very uncomfortable situations in the workplace. It undoes decades of employment law in this state. And yet we're going to debate this. And the question I've been asked is, does this bill have a lot of support in the legislature? And the answer to that question is, I don't know. But I have been consistently been surprised at how much some of these ideas have the support of legislators. And you would think that, employers, businesses climbing out of a pandemic, legislators would be more in tune with the struggles they're having rather than piling legislation like this up on them. But there is very much a divide in the legislature between people who think the pandemic fell harder on employees versus falling harder on employers. And as a consequence, you see a lot of this legislation that's designed to protect or support employees because there's a feeling that they were aggrieved by the employer community when the economy shut down and when the pandemic was declared. And I think folks on this call at least understand that's the last thing that really happened. Other questions I've been asked, Anne Maria, what about what about temporary employees under this law?
The law defines employee as an individual who works for hire, including an individual employed in a supervisory, managerial, or confidential position, but not an independent contractor. So covers everybody. It does have a definition of employer that means a person that's employed 5 or more employees for 20 or more calendar weeks. So it sounds as though employers who have less than 5 would not be covered by this, but everybody else is going to be.
That's correct. What other states no longer have at will? There, as far as I know, only Montana is only one other state has a pure for-cause termination, based on my research, and that was Montana. You may know something different, Anne-Marie.
I don't have those statistics.
Again, there's a misnomer out there though about employment at will, because I think supporters of the bill, advocates are going to come in and say people just get fired for any reason. For those of you who are HR professionals on this webinar, you know that's not the case. And there are a number of protections that are provided employees in this state when it comes to discharge, including whistleblower, EEOC protections, OSHA, National Labor Relations Act, the Maine Human Rights Act, all these different protections for employees. So employers simply can't decide for one reason or another, they're going to fire somebody. But the supporters of this bill would want you to think that that's the way it works currently in the state. I'm certain of it.
Peter, can I weigh in on that for a sec?
Yeah, go ahead.
So I always advise my employers that while technically under an at-will system, you could walk into someone's office today and say, I really hate your pink blazer, you're fired. But that's not smart. And no jury is going to believe that that was the real reason that you fired me. And that's where you get into, there are limitations on what at will means. So in every situation, when you call me up and say, I'm ready to fire this person, is that okay? The first thing I'm going to do is say, tell me what's in the personnel file. What have they been told about what the problem is? What have they been told about how to fix it and what it's going to mean if they don't fix it? And that's essentially what this progressive disciplinary policy is talking about. So do I think it's a good idea to just fire somebody for a reason that seems silly or ridiculous? I don't. But I also think that as long as employers are careful about the way they proceed and are fair and show an employee fairness in terms of, here's the identity of the problem, here's what it's going to take to fix it, and then you didn't fix it, and so here's our last warning, or you're at a point where you're being fired. That's what this contemplates, but I think this is so far overkill of that it's gonna, I can imagine so many scenarios that this is actually gonna put employers in a very difficult and untenable situation where they've got a person in the workforce who is causing such problems that the employer is going to be sued by other people for retaining that person in the workplace, like a harassment situation. And yet under this amendment or bill, you can't get rid of them. Unless on the same day, I'm going to give somebody a verbal warning, a written warning, and a final written warning, all for the same incident. If you want to get cute about it, that's the way you play this. And that's not helping anybody. That's just ridiculous.
The other thing that I intend to remind the committee on Wednesday is the counterweight to employment at will is an employee can walk out of a place of business with zero notice at any time and go to work for somebody else. And that can be despite the fact that you may have spent thousands of dollars to train this person to do a job. There is nothing that compels an employee to stay at a place of business. They can take their talents, as LeBron James says, to Miami Beach or anywhere else they want to go. And yet they want to change the playing field to tie the employer's hands when it comes to discharge.
You're exactly right. There's nothing in this bill that limits an employee's essentially at-will rights to walk out at any time.
Real quick before because we have a couple of other major bills to cover, but I want to get this question in regard to using a temp agency. Would the agency be held to this, or would the company who brought the employee in temporarily have to keep them on, even if it was for a set period of time?
Well, the quick answer, there's a very long answer to that, but the quick answer is it depends on who's acting as the employee's employer. If it's a temp agency that retains employment of that person and is just loaning them out and retains control over them, then it would be the temp agency who is responsible. But a lot of times those end up in joint employer situations where not only the temp agency, but also the employer who's using that person stand in the place of an employer. And so the answer is going to depend on that. But from the language of this, it's not at all clear what the answer would be. I'm getting heart pain from this, I got to tell you.
I'm going to remind people again, the public hearing on this bill opens at 10 a.m. on Wednesday morning. And even though I'm not a fan of the virtual testimony and meeting virtually, it does make it incredibly easy for any of you to participate in the process. And I will put a link in the chat section. I'll find it while Anne-Marie is talking about our next bill, where you can register to sign up for any public testimony. You just pick the Labor and Housing Committee, you pick the date, and you pick next Wednesday, which I believe is the 25th, and LD 553 is the only bill they have scheduled. There is a reason for that. They expect a big crowd to testify on that bill. I'm sure proponents and opponents, but I will put the link in the chat box. So any of you who are interested in either showing up to testify, and I hope you'll consider it, and or submitting testimony in writing would do so. The next bill is LD 225, an act regarding the treatment of vacation time upon the cessation of employment. This bill had a public hearing. I'll let Anne-Marie talk about what it's going to do. The chamber did testify in opposition to it. Yesterday, the bill was scheduled for a work session, but proponents of the bill brought in an amendment and it hadn't been shared with any of the stakeholders. So they made the decision to table the bill. And we still haven't seen the amendment language. I can talk a little bit more about what I'm hearing about the bill when Anne-Marie's finished with her analysis.
Yeah, so this is kind of a sleeper because unlike the last bill that was very, very long and involved, there's very little language to this bill. So when you first look at it, you know, it's got a couple of underlined phrases and that's it. And you think, well, there must not be much to that. You know, that couldn't be further from the truth. So what this bill does, it's amending section 626 that talks about vacation pay for employees. And as I'm sure our participants know, the current law is that if you have a provision for paid vacations based on accrued time, then those paid vacations have the status as wages earned and owed if the employee were to leave. But you dictate that based on your policy. So you decide what we're going to allow to accrue and what's going to have the status of a vacation owed upon someone's leaving and how much people can roll over. And all of those things are what you decide. What this bill purports to do is to say that on termination of employment, all accrued vacation paid must be paid to the employee regardless, period. So what that appears to mean is that no matter what your policies say, if somebody has accrued vacation time, they are going to be owed that time no matter what. Now what it does not address is whether or not retroactive time that currently exists on your books is covered by this law. So you may have a policy that says, we don't have any, we don't put any limit on how much vacation time someone can bank. But if you leave, we're only going to pay out 2 weeks of that time. So that you can have a policy that says that. If this bill passes, and if it doesn't further address retroactivity, or it says it does apply to time that's already accrued, you conceivably would then have to pay out all of the time, not the 2 weeks, but the 850 hours that you've allowed this person to accrue, which can be crippling to the financial status of a business. The other thing it does not address at all, and I don't know how they're going to figure this out. I mean, this would have to be clarified, is how this applies to a PTO policy. Because a lot of employers, especially now with the earned leave time, have revised their policies to not distinguish between sick and vacation, but instead have just a broad PTO bank. So this does not address what that means when you don't actually have time that's called vacation time, and whether it would then incorporate all of your PTO, which before had included sick time, meaning you're going to pay an employee for all of that time now, or whether that's a way around it. I don't know. But this is as big as the at-will employment in a different way, because this is going to have an enormous financial impact on employers. And as you and I talked about, Peter, could potentially mean that employees are no longer going to be given entitlement to vacation time, which I think is the exact opposite of what it was trying to accomplish.
Yeah, and we've had a number of questions, not surprisingly, show up in the chat box, and
We're not going to answer for most of them, just so people know.
Yeah, and then I'll tell you what I've heard, what the scuttlebutt is around this bill. What about paying out new earned paid leave time? Is that applicable? I would say yes. Anne Marie?
I think it depends on what your policies say about what the time is. But my understanding, Peter, is that one of the reasons to hold it over is that they were considering language about what your terms of employment or established practices mean and how they're going to weigh in on this.
Yeah,
and that doesn't answer that question.
That's true. Could you no longer have use it or lose it policy for vacation time? Or does this mean they can't cap rollover?
It sounds to me like there would be no more use it or lose it. If somebody has the entitlement on the books at the time of termination, then they're entitled to that time. And I don't know what it means in terms of rollover. I mean, it seems to suggest that if you give somebody, let's say somebody under your policy is entitled to 2 weeks per year, and they accrue that time and they have it, at the end of the year, we previously have been able to say, well, if you don't use it by the end of the year, we're not going to roll it over, you lose it. This insinuates that that's not going to be the case.
So this is what I've heard about this bill on a going forward basis. There are certain advocates, first of all, they don't want to include, the intent is not to include sick time. The intent is just to make this about vacation time. But there's a division amongst the supporters of the bill, whether there are some that want to roll everything into the payout scheme. So that would be vacation time, PTO time, earned paid leave time. I have not heard anything about trying to prevent capping of rollover or prevent a use it or lose it policy. So I think the danger for the employers, and I'll let Anne Marie speak to this from a legal perspective, is if this passes, you need to look at what your policy is now regarding vacation time. Let's just say it's vacation time. If you allow rollover, then going forward, they're not saying there's nothing in the language that says you can't adopt that policy. That's bad for progressive employers and their employees. This is a bad change because if you're an employer who allows rollover or banking of unused time, you're going to put an end to that. Because that's going to be all of a sudden either you cap how much your payout is, say you only will pay out 4 out of a maximum 6 weeks or some portion thereof. That's a liability on your books. And any accountant is going to look at all your employees and how much bank time you have as a financial liability. And they'll want that changed. So I'm not sure that at the end of the day, there is talk of an amendment. None of it sounds good. One of the amendments, for instance, is to exclude from this law any collective bargaining agreement, which means, this won't apply to a union shop, but would apply to all others. There's concerns about what this would mean for municipalities and whether this constitutes a mandate for municipalities. So there's also talk about perhaps excluding the public sector from this bill, which would include the state, which means it would only fall on the backs of private sector employers. And then lastly, around earned paid leave, I think the intent is to include earned paid leave because there are advocates who wanted that included in the law last time around. And as all of you are aware, the Department of Labor's rulemaking did not require cash out, only if you cashed out other forms of vacation or leave time as a policy with your employees. So in other words, consistent with the current law. But I think they want to require it all to be cashed out. As far as PTO goes, I haven't heard of any language which would include PTO in this. But again, this is the very early stages on this. And I do know that obviously the business community is at odds with this. This is being driven by organized labor and the FL-CIO. And I do know that the governor's office has concerns with this bill as it's currently drafted, even though they testified neither for nor against in the public hearing. Question, Anne Marie, and correct me if I said anything wrong, please. So if an existing written policy has 3 categories of leave, vacation, sick, PTO, is the recommendation to leave the policy as is?
I can't make any recommendations about that.
I don't know the answer to that yet.
We don't know what the intent of this is. I mean, if you look just at the language that they've proposed, the way the sentence would now read is, whenever the terms of employment or the employer's established practice and includes provisions for paid vacations, all accrued vacation pay must be paid to the employee on cessation of employment. That does not suggest clearly to me that it's a use it or lose it. Because once I've accrued it, I mean, I can see the argument in the employee groups. Once I've accrued it, it's mine. And if I don't use it that year, then I don't lose it under this amended language. So I think when that work session addresses established policies, that presumably that's something they're going to have to, I mean, obviously that's going to take clarification because, if the intent is just to say an employer can limit somebody's vacation time, let's say I'm going to give 2 weeks a year. And what I'm going to say is you're only entitled to roll over 1 week. You can never have more than 2 weeks on the books. The intent of that in my mind would be that I would never owe you more than 2 weeks of vacation time were you to leave. And that would be less, of course, if you used any. So that would limit my exposure under here. But unless it's made that clear, then anything that's already been accrued and is on the books, so that's the first issue. Do I have to pay that out under this law? And which is inherently unfair, I think, because if I have an employer who's allowed somebody to accrue 800 weeks of time, just because I'm a nice person and I assume you're never going to use that much, I now owe thousands and thousands and thousands of dollars to that person. And then the second issue is, does this mean that once you earn that day, it never goes away until you either use it or you leave, in which case I have to pay you? And the effect of that, I see, is that employers are going to stop providing vacation pay as a benefit or vacation time at all, and just say, well, everybody now gets up to 40 hours of earned leave time, and that's all we're giving. So period, that's it.
Couple of questions. There's one other bill we really need to touch on before we finish, but question, I expect this is an unknown at this time. However, what if you front load yearly PTO to use at any time, but the policy has an earned accrual by month? Would this bill cause the employer to have to pay out based on the full front load of PTO versus what was earned but not used?
I don't think either of us is in a position to answer any specific questions beyond speculation, because there's just no way to know from the current language.
I have a question on earned paid leave of clarification. Can you please clarify earned paid leave? Our understanding is that EPL does not need to be paid upon termination. Is that needing to be consistent with our policy for PTO? Thank you.
I didn't bring the earned paid leave statute. My recollection is that you as the employer drive how it's paid out or not paid out. And that if you don't have a specific policy that says how you're going to do it, then the payout scheme reverts to your vacation policy.
That is Again, the statute on earned paid leave is silent on cash out. So you need to go to the rules that the Department of Labor promulgated, and you can go to the Department of Labor's website and find those rules. And I believe the way it states is that if you have a policy that pays out vacation time, and it may be other forms of leave, I'm not sure, then when someone leaves, their unused EPL has the same status as their wages earned, and you would need to cash it out. If you do not have that kind of policy, then I believe what the rules state is that the employer is required to keep the unused portion of the leave for that employee on their books for a period of 1 year, in case the employee is a seasonal employee and returns to the place of business. And if they return, then they start accruing leave from whence they left off. I believe that's how it works.
I think the second part of that is right. I think, and we'll have to look to be sure, that you can have a separate policy about how EPL is paid out. But if you don't, that's when it reverts to whatever your normal vacation policy is. But we can look that up and
yeah.
Sure.
Yeah. I'm going to jump to the next bill because it's equally important and has an equally important impact on the workplace, and that's LD 607, an act to restore overtime protections for Maine workers. This bill has a public hearing on Monday, and much like LD 553, I strongly encourage folks on this call to consider testifying in opposition to the bill. I will be testifying in opposition on behalf of the chamber, or submitting testimony in opposition in writing to the committee. This bill was submitted and worked in the last session. It was LD 42. It actually came out of the Labor Committee as an ought to pass bill 7-6, but it did have one Democrat senator, Shenabellos, in opposition with the Republicans. The bill went to the full legislature, but died on the table when the legislature adjourned due to the pandemic. It's back this year. Anne Marie, I'll let you touch on what its intent is.
Yeah, it's compared to the other ones we talked about, it's pretty simple. Basically, what it does is it amends Maine's overtime exemption rules, which currently base an exemption salary on 3,000 times the state's minimum hourly wage. And what this does instead is that it sets a schedule for what that minimum amount needs to be in order for the employee to qualify as an exempt person. So the changes would start as of October 1, 2021, and the rate at that point is 33,000, and then it raises it each year after that up through 2025, at which point it starts to depend on the Bureau of Labor statistics and numbers from the DOL. So essentially, it's setting new thresholds for what it takes to qualify as an exempt person from overtime in the state.
Obviously, this is a significant issue. So California has two different standards for overtime. If you have more than 26 employees, your overtime threshold is 58,000 and change. If you have less than 26 employees, your overtime threshold is 54,000 and change. Washington State has a threshold that's higher than the federal, and it's higher than Maine's. And there are a handful of other states, and then 2 counties in New York State around New York City also have higher thresholds in the 50s. But other than that, Maine would have probably, as a state, the second highest salary threshold in the country, only behind California.
And just to make sure everybody's on the same page with this, in order to be an exempt employee, the person has to not only meet the duties test, they also have to meet the salary basis test, and that's what these numbers are talking about. So they have to be in an exempt position in terms of their duties, but they also have to earn at least a certain amount, and that's what these numbers are.
And we had a statement come in on the chat. Isn't the minimum 36,450 now? What did you say is the new proposed date? The new proposed amount by 2024 would be $55,250, I believe. It would jump up. It's interesting. The stat, I think there's a drafting error in the bill because it says effective in June of this year, it would drop to $33,000. Well, that's not going to happen. That's somebody just lifted the language out of the original version of LD 42. So I think that's a drafting error. In January, it would make the first leap into the 40s. There's a subsequent leap the following January of 23, and then in January of 24, it would go to 55,000.
Right.
And again, this is up for public hearing on Monday. I mean, think about again, this issue, you all will remember when the Obama administration did rulemaking under this, to address the low threshold that had been in place. It hadn't been adjusted since Bush was president. It was 23 and change. And you will remember that the Obama administration's final rule was north of $47,000. And they were sued in federal court. And a court in Texas struck down the rulemaking by saying that the amount of the size of the increase was so significant that it essentially rendered all the other tests that Anne-Marie just went through was meaningless. That was their basis, as I remember. Anne-Marie, you may remember it differently. So the Trump administration did promulgate rules, and they became effective on January 1st of 2020 that places it where it now was at 35,000 and change. But Maine is already above that. So this would be a significant increase beyond that.
And if we're higher than federal, then employers in Maine have to comply with these numbers, the state numbers, not federal. So.
And again, it's going to go up next year. It's going to go up every year because we are tied to increases in the minimum wage. And the minimum wage is going to be indexed on an annual basis by changes to the urban CPI. So we went up 15 cents this year. We'll probably go up another 15 cents next year.
But not at the jumps that are contemplated here.
No. Any more questions on that? Again, you can, I did put the link in chat. If you want to sign up to testify or submit written testimony on this on Monday, very important piece of legislation. Last one real quickly is LD 610, an act to amend the laws governing employer recovery of overcompensation paid to an employee.
Yeah, just this has so infrequent application that it's not anywhere near as sort of mind-boggling as the other ones we've talked about, but it's worth mentioning. And that is that there's some changes to the way an employer can try to recoup over compensation paid to an employee. So it used to be, and there again, there are a lot of limitations on this already. This is not something to be taken lightly. You can't just take money back from somebody under any circumstance. There are rules already to follow, but essentially the biggest change to it is that it will now say that an employer who overcompensated an employee through employer error cannot recover more than the amount of overcompensation paid in the 3 years prior to discovering the error. So in other words, you can't go back and say, we've been paying you more than we should have for the past 10 years, and now you owe us, $10,000. But again, this has far more limited application than the other things that we've been talking about. And but we wanted to at least make sure everybody knew that this was out there.
I think that means we are about out of time. It's about 5 minutes after 11, and I know that our presenter has other obligations. I have just put a note in chat which says if anybody has any questions about the legislative process, to feel free to email me at my email. Hang on, I'll copy that. I just got a request for the link again. And there's the link to how to sign up to testify or submit legislation once again. And again, if anybody's interested in doing that, email me and I'll make sure I'll get you the information. Or you could call
You may
me.
want to revisit some of these, Peter, after these work sessions and after there are potential amendments to some or clarifications to some of these.
Yeah, I think you can look for a follow-up to this. We're not done. They're only at about 1,100 bills, and they expect to have about 1,800 printed. There are other labor bills to come, and there are a lot of titles that are known as concept drafts that can be filled in with anything really at this point. They're simply vehicles. So with that, I want to thank everybody for joining us this morning. We've had a great crowd and folks have stayed on throughout the whole presentation. I want to thank our sponsors, Rudman and Winchell and Husson College, for their support this morning. Look for a follow-up webinar down the road. And in the meantime, I hope you all stay safe and you have a great weekend.
Thanks, everybody. Thanks, Peter.
Thank you, Anne-Marie.